Thank you for joining us, Mr. Shivang Puri. Congratulations on your recent victory regarding the refund of education and CESS under area-based exemption. Could you provide us with some background on the case?
Thank you so much. Basically, to give impetus to certain areas, the government had introduced area-based exemptions. Now, under these area-based exemptions, the excise duty and certain related cess were in a way refunded. So there were two ways of refunding this cess. One was through self-credit and other was through a basic application and filing of your returns. The specific issue that we were facing in the particular case that we are here discussing was that the education and SHE-CESS, the secondary and higher education cess, these were introduced by Finance Act 2007 and 2004 respectively. 2004-2007 respectively. So the issue was that the notification in question was notification number 56 of 2002. So that notification specifically talks about duties of excise. However, as I pointed out, that these cess came into existence only after 2004 and 2007. So the question was whether these cess will be covered under the exemption notification or not. And particularly, this was a highly contentious issue, and in 2017, I believe, SRD judgment came in, which specifically stated that you are entitled to get a refund of the education and SHE-CESS as well. However, 2 years down the line, the unicorn judgment came in, which said that no, because at the time of making the exemption notification, the lawmakers could not have envisaged that SHE and education cess would also be covered under this notification. Therefore, you will not get a refund of it. In our particular case, what had happened was that, so in this background, it is also very important for you to understand that as per the notification 56 of 2002, there was a determination of whether you are liable to get the refund or not. Once that determination was done, recovery was undertaken in case you don't reverse back the refund. So in that context, wherever recoveries were being initiated on the basis of unicorn judgment, wherein determination or maybe some decision of the lower authority has already happened on the basis of SRD judgment, there was a decision of the Honorable Supreme Court on this matter itself, that is Saraswati Agro. And the Honorable Supreme Court said that once you have decided the matter based on the SRD judgment, then you cannot now open recovery proceedings on the basis of unicorn. However, in our case, due to expedited litigation, the recovery proceedings were adjudicated, while as the determination proceedings were left in abeyance. So that posed a unique question before the tribunal as well, and to us as well. So this is the background in which we fought the case.
Okay, so what were the main argument you presented on behalf of the client during the proceedings?
So mostly the number one thing that we argued before the tribunal was that you have to realize that once you are deciding what is liable to be recovered, you would have to be determined if that can be recovered or not. Without that determination, no recovery can go ahead. And that is precisely what we pointed out, that let us say if tomorrow, because we had a favorable judgment on the basis of SRD in the recovery proceedings, so we pointed out that once it is before the Honorable Tribunal, and they even challenged that order before the High Court, and then it went to the Supreme Court as well. So they would have definitely decided whether we are liable to get the exemption or not. It is only then that they would decide whether that recovery is valid or not. So therefore, determination itself has been done, and it was before consideration, it was duly considered by the Honorable Tribunal and the High Court as well as the Supreme Court. Additionally, we argued that this is an entirely academic exercise. Let us say if today, because the recovery proceedings are already over by the order of the Honorable Supreme Court, so let us say if today they decide as well that it is determined based on the unicorn judgment that you are liable to pay the education cess. What will the department do? There is nothing that they can do, because the limitation period which is there for issuing recovery is now over. So this is an entirely academic exercise. The recovery cannot be done. So we are wasting the time of the honorable courts. And if today the tribunal gives us a decision that goes against us, we'll just go before the honorable high court and we'll seek a relief. So it is increasing litigation, it will increase lists. So in that context, we had argued that as determination has already been done, and because even if the revenue wins, there's nothing which will happen. So in that context, the benefit should be given to us.
Okay. It sounds like a complex legal battle. What were some of the key challenges you encountered throughout the litigation process?
I think the biggest challenge was obviously the unicorn decision. The unicorn decision in 2019, as I pointed out, specifically said that education cess and SHE cess are not liable to be refunded for these area-based exemptions. Now the issue was that the determination order that we were challenging had specifically relied upon the Supreme Court's decision. Now, for any authority to come out and say that no, this reliance is wrong is very difficult, because that's the apex court of our country, and it is very difficult to distinguish as well. And what the revenue was also harping on was that if you look at the Saraswati Agro decision, it only says that no recovery can be done. It doesn't say that determination cannot be done. So they were saying that we agree that determination, that recovery cannot be done. However, as far as this proceeding is concerned, it is only pertaining to determination. So they were harping upon the fact that whether we can make recovery or not is separate. However, on determination based on unicorn, you give us this decision. And it is very difficult. It was very difficult to explain this situation to the tribunal as well. And we actually took them through each and every show cause notice, and we showed that these were covered by 5 show cause notices. So we showed them in every show cause notice that during the recovery proceedings as well, they are specifically pointing us the reasons why they are saying that recovery is being done. If it would have been the case that they determined through a separate order, and then on the basis of that order they are doing a recovery proceedings, that would have been different. However, if in the recovery proceedings itself, if they have determined that we are not liable to get the refund, and then they have then challenged it before the honorable high court, before the tribunal, and then the high court, and then the Supreme Court, and the Supreme Court has already given us in the favor. So then the determination is set, and now the lower authority or the tribunal or the high court cannot take a contrary stand. So that is how we argued it.
And your efforts certainly paid off with a favorable outcome. Were there any specific legal principle and precedents that played a crucial role in the court's decision?
I have already noted a few. I have already given account of a few. One thing that also played a very important role, and we had discussed this before the Honorable Tribunal, even though this discussion was not made part of the record because it was not directly relevant. We had discussed about the unicorn judgment itself in the context of Modi rubber. So SRD nutrients case came in. It was in the favor of the SSEs. Everyone was very happy with that judgment. And then the unicorn judgment came in, which said that the SRD judgment is per inquirium, that is that it is wrong and it has not considered a few things, because it did not consider the Modi rubber case. Now Modi rubber case was a landmark case. It is very important to note that in the SRD nutrients case, the Modi rubber judgment was relied upon by the revenue. So in their submissions, they had provided specific mentions to the Modi rubber case. However, the Honorable Supreme Court in all its wisdom did not discuss it, and there is a reason for it. The reason is that the inherent nature of the cess in the Modi rubber case, as well as in our case, that is the education and SHE cess, are entirely different. The education cess and the SHE cess are a surcharge. As per the constitution, a surcharge, I believe it is 271, it says that the surcharge is an addition of the main tax. So if in very simple terms, a surcharge of water will be water only. So if I say give me a surcharge of water, it will not be cola, it will not be orange, it will be water only. So once you say that it is surcharge, it takes the character of that duty. And because the SHE and the education CESS are a surcharge of the excise, so therefore these are duties of excise. That is number one. The second most important thing was that education CESS and SHE CESS, these are piggyback duties. Now what I mean by that is, these are computed not only on how much excise duty is leviable. The term which they use is levied and collected. So not only should it be levied, it also needs to be collected. So for example, if 100 rupee excise duty is levied, but collected is only 50. So education and SHE CESS will only be levied on the 50 rupees and not the 100 rupees. So we argued very specifically, and this has been argued multiple times, maybe in the revision petitions the Honorable Supreme Court will take up this argument, that there is an inherent difference between SHE CESS and education CESS and the NCCD CESS, maybe, which was considered in Unicorn, and the additional duty of excise that was considered in Modi Rubber. So in those cases, those were dependent on the value of the goods or services provided, whereas in our case it is on the levy as well as collection. So if the collection in our case is zero due to the exemption, and there is no doubt about it, then the education CESS and SHE CESS is also zero. So on that basis as well, we argued that it is not liable. And even additionally, in a very recent case pertaining to customs matter, Honorable CESSTAT Ahmedabad, they gave a very fine decision saying that when we are discussing SHE CESS and education CESS in the context of customs, it is on the basis of customs duty, that is BCD, basic customs duty. When the BCD itself is zero, how can there be any issue regarding payment of education and SHE CESS? Over there the issue was different. The issue was whether you can deduct these amounts from scrips, duty scrips. They said that whether these amounts can be paid from scrips or cash is immaterial. You don't have to pay, because if the BCD is zero, it makes no sense for you to discuss whether it needs to be paid through scrips or through cash. So ultimately we had argued that the SRD nutrients case was correct. However, obviously it is not the Honorable Tribunal's place to discuss and decide whether which Honorable Supreme Court's case was correct. Obviously revision petitions are there, it will be argued in due time.
Okay, looking ahead, how do you anticipate this ruling will impact future cases involving similar issues related to refund of education and SHE CESS under area-based exemption?
Yes, so definitely it will have a great impact, because what had happened was that after the Unicorn's judgment, in our case also, they went ahead and expedited the list on, as I pointed out, they expedited the list on recovery side of the proceedings, but the determination side they left it into abeyance for multiple years. And once the Unicorn judgment came in, they issued show cause notices left, right, by they as in revenue issued show cause notices left, right and center, and whatever proceedings were left in abeyance, they revived those proceedings as well. And we are aware that this is being argued in multiple places, that these are determination proceedings and these are separate from recovery, which has been covered under the Saraswati Agro. So therefore at least determination should be done. Now our issue is that despite clear instructions and despite being beyond the limitation period, the department issued show cause notices after the Unicorn judgment in 2020. Unicorn judgment came in 2019, show cause notices were issued in 2020. So we are not sure if after these determinations, once again, despite the fact that it is beyond limitation, they'll again issue show cause notices. So that is one concern that we had, and that is why we pushed as much as possible to get a relief at this stage only. And moving forward, if we read this judgment along with the CESSTAT Ahmedabad judgment pertaining to customs matter, this has brought clarity. You cannot put things into abeyance and use that as a loophole to now initiate proceedings again. So as we say, chid bhi meri, pad bhi meri is not allowed now anymore. So very, very positive impact towards this specific subject at least.
Okay. Thank you, Mr. Shivang Puri, for sharing your insights, and congratulations once again your success.
Thank you so much. Thank you for having me.